This webinar on procurement and anti-corruption efforts, an update from Brazil. This is the next in a long series of webinars we've had that have been quite successful. We have guests and participants from around the world. We'd like to welcome you. Today we have over 260 registrants from 56 countries from around the world, and we're very, very glad that you could join us in this discussion today of what's going on in Brazil. I'm Chris Eukins. I'm a professor at the Government Procurement Law program at George Washington University Law School. Just a few mechanical details. The recording and the materials from today's program will be available at publicprocurementinternational.com. I've already posted in the chat. I posted the link to those materials if you'd like to look at them. We have extensive materials on the developments in procurement and Brazilian procurement law that we'll be talking about today. The recording will be available there on publicprocurementinternational.com on that page, and will also be available at the GW Law Government Procurement Law YouTube page. The Q&A function, the question and answer function, should be enabled for today's session. Please feel free to put questions up there. We very much welcome questions from the audience. And their speaker statements today are in their personal capacity. In that regard, I want to make special thanks to Rafael Tonicelli, who has contributed. He's a senior lawyer in Brazil who's contributed a number of papers that he developed in part in a class that he and I did at the International Anti-Corruption Academy. And those materials are available as well at publicprocurementinternational.com. Some very interesting papers talking about anti-corruption efforts in Brazil. Today's session is focusing on really what's happened, how the anti-corruption efforts have pivoted in Brazil since Operation Car Wash. Public procurement in Brazil was buffeted, really changed by the Operation Car Wash corruption scandal that we'll be talking about. And now there's been a wave of reform. That wave of reform is what we'll be focusing on today. It's being redirected under the re-elected president, Luiz Inácio Lula da Silva. Lula himself was tarred by the car wash scandal, and he was spent 580 days in jail before Brazil's Supreme Court ruled his imprisonment unlawful. President Lula won the presidency again, and then his new administration withdrew Brazil's coverage offer for entry into the WTO government procurement agreement. So it didn't completely withdraw from the accession process, but didn't go to the next step, and we'll be talking about that. This was an abrupt U-turn from the market opening initiative, the Bolsonaro administration's agreement to start the accession process with the GPA. So in this 1-hour webinar, we'll be led by academics and attorneys from Brazil. We're going to be discussing this most recent developments under President Lula regarding anti-corruption, contracting, and talking about the future direction of public procurement in Brazil. I want to make a special welcome to our colleagues from South Africa. There was a conference last week in South Africa, and South Africa is working on a draft procurement bill, and in many ways, they're very interested in what's going on in Brazil in terms of anti-corruption efforts. The anti-corruption efforts we'll be talking about today, the legislative and the regulatory reforms we'll be talking about today. So a special welcome to our colleagues from South Africa. We just want to introduce our panelists today. The first is Mauricio Menezes. I apologize to Mauricio in advance for my terrible Portuguese accent. No problem. He's a full professor of business law at the University of the State of Rio de Janeiro and a partner of Moreira Menezes Martins Advogados. He specialized in business law, including corporate mergers and acquisitions, capital markets, banking, business contracts, bankruptcy, anti-corruption, and arbitration. Renata Costarino is a visiting scholar with us at GW Law School and a doctoral student in administrative law at Universidade Federal de Minas Gerais in Brazil. She's a lawyer specialized in administrative law, including infrastructure, PPPs, government contracts, bidding procedures, compliance, and anti-corruption. On a personal note, I want to say how grateful we've been to have Renata as part of our program this year. Cesar Pereira is a partner at Justin Pereira Oliveira and Talamini, based in Sao Paulo, Brazil. He's co-head of his firm's practices in infrastructure and dispute resolution, arbitration, and mediation. He has a doctorate in administrative law from PUC-SP in Brazil and has been a visiting scholar with us at GW, at Columbia University, and the University of Nottingham in the United Kingdom. He's a fellow of the Public Procurement Research Group at the University of Nottingham. And with that, I'm going to go ahead and turn it over to, Renata, who will talk first about the anti-corruption efforts, and then Mauricio will talk about efforts in compliance in the wake of Operation Car Wash, and then Cesar will close out talking about the trade issues. Renata, if I could, I'll go ahead and advance the slides for you with your instructions.
Yeah, that's great. Thank you. So first of all, I'd like to thank Professor Junkins, GW Law, everyone that has helped put this webinar together, and of course, all those attending it. Thank you all so much. I appreciate it. So today I have the challenge to talk about anti-corruption in the wake of Operation Car Wash. The Lava Jato, as we say in Portuguese, or car wash operation, began around 2014 as a money laundering investigation that reportedly took place in a car wash, inspiring its unique name. It has revealed an extensive net of domestic corruption, foreign bribery, and money laundering offenses involving Brazilian companies, politicians, political parties, powerful businessmen in Brazil, state-controlled companies, and so on. I will not go deep into the operation, which has a lot of its judicial and administrative outcomes still ongoing, being extremely controversial in Brazil until this day. However, from my point of view, it is important to acknowledge it. After all, it became known worldwide as a successful operation, revealing wrongdoings and leading to the recovery of a lot of assets for Brazil. And unfortunately, this hasn't been the first major corruption scandal in our country. The Brazilians listening to us now will recall a lot of others, such as one called Mensalão, a corruption scandal dating back to 2005, in a very similar line of action of car wash, using state-owned companies, politicians, and private entities to corrupt and launder money for political and personal gains. So what is the difference among car wash operation and those previous ones like Mensalão that I have mentioned? Why was car wash so big and able to reveal a much broader scenario? In my perspective, the answer to that, among other facts, relates to the legal framework, the enforcement of the law, the due process of law, and the transparency tools, as we can see in the slides. And that's because car wash took place in a moment that Brazil's legal framework had been updated throughout several years. And this is much related to the anti-corruption conventions like OECD's and UN conventions from the late 1990s, when Brazil became internationally committed to applying anti-bribery measures in the country. So that's why, by the time the operation began, the competent authorities could use a lot of new tools, like plea deals from the Crime Organization Bill, leniency agreements from antitrust and anti-corruption bills, mutual legal assistance, or as we usually say in Brazil, international cooperation with foreign authorities, among others. And those helped, for example, with self-disclosure from the corrupt companies and their compliance programs, providing a path for the authorities to follow and uncover a much broader endemic corruption, like we have all seen. So the way I see it, the consistent improvement of our legal system is of great value in our efforts against corruption, and it has definitely provided the proper background for the enforcement of the law to all, which of course needs to respect the two main controversial elements in the mentioned operation by now, which are the due process of law and transparency for the appropriate accountability. We can go to the next slide, please. So the updates and lessons learned in Brazil keep on going regarding the development of the legal framework to offer the proper background to prevent corruption in government contracts. And as a lawyer and a researcher in this field, I have chosen to highlight 3 bills that have recently been updated. So the first one is the Clean Companies Act. It dates back to 2013, and I will show you in the next slide in a few minutes that the act has been increasingly effective in Brazil as a bill that protects both national and foreign public administration against wrongdoings carried out by enterprises, and mostly of those wrongdoings concerning bidding procedures and government contracts. Relating to this topic, it is relevant to acknowledge the new federal decree from 2022, renewing the bill's regulation and improving its legal certainty concerning, for example, the standards for evaluation of the compliance programs, the CGU's authority, which is one of the main agencies in Brazil in the fight against corruption, among other developments. It is, of course, worth reminding that compliance is a penalty mitigation under Brazilian anti-corruption bill. So the second extremely important bill to highlight is the new public procurement bill from 2021. It will be mandatory by the end of this year, and it regulates our bidding procedures in just one major bill, revoking other acts. And this provides an easier background for both national and foreign companies willing to invest in the Brazilian market. Also, this public procurement law has created a national portal of public procurement, the PNCP for its name in Portuguese, therefore improving elements like standardization, transparency, and accountability. And another interesting addition to point out today regarding this law is that this act has given the anti-corruption compliance an increasing relevance with 4 new provisions. So now, within this bill, compliance becomes 1, mandatory for tenders with values above 200 million reais, which is Brazil's currency. 2, one of the tiebreaker standards during the bidding procedure. 3, a factor to be considered in the imposition of sanctions due to administrative wrongdoings under the public procurement bill, somewhat similar to the penalty mitigation under the Clean Companies Act. And 4, a condition for rehabilitation of a bidder or contractor from a previously imposed punishment. And next, the third important norm to highlight is the Improbity Act. It dates back to 1993, and it was recently reformed in 2021, considering, among others, the anti-corruption conventions Brazil signed. And this reform improves legal certainty in the sanctioning of public officials in Brazil in a clear effort to establish a long-needed balance in the enforcement of this law. So this one is also a considerable improvement to highlight in the public procurement market in Brazil. We can go to the next slide, please. On this slide, we have a print of one of the transparency improvements provided by the updates in Brazil's legal framework. And this particular one was provided by the Clean Companies Act, and it is available in the so-called transparency portal. In this print, from an official website open to all, anyone can navigate through it. We can see relevant information regarding public procurement and corruption, such as companies punished under the Clean Companies Act, leniency agreements, debarments, suspensions, and others. So, for example, we can see in this slide that from 2013 until this year, by the time I printed the website a few days ago, 527 companies had been sanctioned under the Clean Companies Act, and over 100 had signed leniency agreements concerning the anti-corruption bill. The last time I checked, the portal was available only in Portuguese, but it is really easy to navigate, and I strongly recommend it for anyone interested in knowing more about Brazil. And I will try to put the link to this website on the webinar chat, if possible, in a few minutes. We can go to the next slide, please, Chris. Thank you. So reaching the end of my presentation, I will point out a few challenges for the future in my perspective. So the first one concerns whistleblowing, which is my main research here in the US as a visiting scholar at GW. So Brazil already has whistleblowing provisions, but it needs to improve its legal framework regarding whistleblowing as an instrument for anti-corruption efforts. And this, it's interested to point out, was also highlighted by the OECD's Force Monitoring Report on Brazil, dated October this year. In my research, I advocate for a better regulation of proceedings in Brazil, such as the one provided by the False Claims Act here in the US, along with additional protective measures for the whistleblower. The second challenge for the future I chose to highlight is legal certainty. To encourage investments in our public procurement market, such as our public-private partnerships, among other government contracts, for example, for infrastructure projects, the most needed ones for developing countries. It is essential to provide legal certainty, therefore enhancing competition and fair prices. And Brazil has been increasingly addressing the issues regarding this matter with the legal reforms, but it needs to be a consistent improvement. And finally, I have talked about how anti-corruption compliance programs have gained an increasing relevance throughout the years in Brazil. By now, its relevance for companies investing in the public procurement market is undeniable. But in addition, it is worth pointing out that Brazil could incorporate more incentives based on the best practices studied worldwide, such as compliance as an affirmative defense, which could be a higher incentive for self-disclosure. And this is really important looking forward, considering that the OECD's Force Monitoring Report on Brazil stated that some of our agencies identified self-reporting as the most common source for detecting foreign bribery in Brazil, what today happens with the leniency agreement, but could have an additional incentive with compliance. So those were the considerations I would like to share with you today. Thank you very much for your attention, and the floor is back to you, Chris.
Thanks very much, Romana. We just note that we have a question from Jean-Jacques Verdot for you in the Q&A. Jean-Jacques, so you know, Jean-Jacques is a folk hero in our program. He wrote the first comparative piece for the Public Contract Law Journal. So if you could answer his question, he works at the World Bank, that'd be great. Thank you. With that. Mauricio, the floor is yours.
Okay. Thank you, Professor Christopher and Renata, for the invitation. It's an honor to be here sharing some ideas with you. I'd like to describe to all of you the panorama of Brazilian companies' adherence to international anti-corruption compliance standards. I will start with a summary of what's been happening in the past 10 years, especially since the advent of Operation Car Wash, and how the consequences of this mega investigation have affected the routine of Brazilian companies and the business environment in general. Before the enactment of the Clean Companies Act in 2013, little was said about the anti-corruption compliance of Brazilian companies, except for those with foreign corporate control, especially the subsidiaries of American multinationals. In my opinion, Operation Car Wash sped up the adoption of anti-corruption compliance practice in both the private and public sectors. Mid-sized and large companies woke up to this new legal reality. In particular, those that were in some way involved in the investigations underwent a bona fide revolution in their internal control systems and their ways of doing business. As known, some faced profound crisis and others had to reinvent themselves. In 2018, I took part in the study led by the ICC Brazil, the International Chamber of Commerce in Brazil. As a member of the ICC's Anti-Corruption Commission, I suggested some questions for the study to address the level of Brazilian companies' commitment to anti-corruption compliance practice. At that time, there was, in the public opinion, a kind of euphoria regarding the improvement of those practices, while also being concerned over the financial health of companies in crisis, especially those involved in Operation Car Wash. Indeed, there were doubts about whether the large companies in the civil construction, for instance, and infrastructure sectors would survive, or the country would have to rely on foreign companies to render this essential service. At that time, we were making progress toward the full adoption of anti-corruption practice, which started to be disseminated among small and medium companies also. So it was important to develop a kind of general balance sheet and perform field work to learn the effective adherence of Brazilian companies to compliance and whether they were really creating and developing a new business environment and culture. Thus, as realized by the ICC, the study was carried out mainly by Deloitte, whose work was really excellent. The survey included 211 companies addressing the parameters, as you can see on this slide. I have some comments here. There was a concern, you can check, there was a concern to have balance between large and medium and small companies. Also, on the right side of the screen, you can see an interesting range of sectors of these companies. Professor, can you go to the following slide, please? Okay. In this study, a list of 30 compliance practices were considered, including adoption of a code of ethics, commitment of top management, financial controls, risk assessment of suppliers, monitoring of employees, whistleblowing channel, international investigation and training, among others. In general, this study shows the consistent evolution of companies in Brazil regarding the adoption of practice for risk control and compliance over the last years. As you can see on the right of the screen, the total numbers on the right of the screen. Between 2012 and 2014, only 24% of the sampled companies had adhered to at least 15 of these practices, while from 2015 to 2017, the number reached 46%. At that time, the outlook was to achieve 65% by 2020, according to the response to the questionnaires by a sample of companies. Although there are no studies proving this achievement, the consensus is that significant progress was made by companies in relation to compliance practice over this period. So this number might be correct. This result reflects a more sophisticated legal system in Brazil, with the enactment of important laws, as Renata explained before, as well as the impact of the investigations carried out by Operation Car Wash. In general, as you can see on the left of the screen, large companies and those with foreign capital tend to be more adherent to compliance initiatives, but there is room for further advances, a reflection of the growing sophistication of the national and international compliance settings, with a greater importance given to a culture of governance, leading to more efficient compliance practice. This progress in the adoption of good compliance practice has also been strong among companies with annual revenues lower than 100 million reais, which is equivalent to $20 million. But these companies as a group are far from the level of large companies still. Professor, can you go ahead, please?
Mauricio, can I ask you a quick question about this?
Yes.
In the US market, it's taken as an article of faith that a strong compliance program, in part because it reduces reputational risk for the government, that a strong compliance program gives a contractor a competitive edge in the marketplace. Is this in Brazil, or is it the same perception?
That's the same perception. That's the same, really. So the idea of this slide is just to give information about the measures adopted by Brazilian companies to detect misconduct or to prevent corruption. Please take a look at these numbers. A huge development if you compare the period between 2012 and 2014 with the period from 2015 to 2017 and the subsequent years. It's really impressive. Can you go to slide 4, Christopher? Okay, thank you. This slide brings brief information about fraud experienced by companies. Again, a brief comment because we don't have much time. 1/3 of the companies interviewed experienced some type of fraud between 2012 and 2017. Please see that 1/2 of the case was discovered by means of an internal whistleblower or control process, revealing the growing importance that the surveyed companies gave to internal defense channels in that period. That's very important. Professor, can you go to the next, please? Thank you. Talking about the main challenges. Well, this scenario of increasing consolidation of compliance, however, has been followed by challenges for broader and more integrated compliance by organizations in Brazil. You may see on the right of the screen, please, the principal challenges indicated by the companies are increasing the scope of the compliance areas and practice, monitoring of third parties, and control of routine activities. These challenges reflect concern over whether compliance is integrated in business strategy and brings value to the organization. Now, if you compare to the challenges, indicated over the period between 2012 and 2014, on the left of the screen, we may conclude that at that time, companies didn't even have a budget for implementation of compliance practice. There were lack of human resource and lack of IT infrastructure. Professor, can you go to the next, please? So here are some issues I'd like to share with you. First of all, the multiple leniency issue. Regarding leniency agreements, a grave problem has arisen. It was the distortion caused by the intervention of the Federal Prosecution Service in reaching leniency agreements in disrespect of the Clean Company Act, according to which competence for this purpose rests with the Office of the Controller General. I will refer to the CGU. CGU is the Office of the Controller General. In addition, at that time, 2018, there had been resistance from the Federal Audit Court, I will refer to TCU, to the exclusion of the department from public procurement. The TCU established that it had jurisdiction to decide on the legality of leniency agreements involving contracts with the federal government. This jurisdiction was part of its, may I say, oversight powers and didn't involve participation in the negotiation of those agreements. In 2020, TCU, the Office of the Solicitor General in Brazil, the Ministry of Justice, the Federal Prosecution Service, and the CGU signed an agreement for technical cooperation for this purpose. Brazilian companies, of course, welcomed this official agreement, at least to the extent it will avoid what happened to Odebrecht, which signed an agreement with the Federal Prosecution Service that was subsequently invalidated by the federal court for disrespecting the competence of, competence rules established in the Clean Company Act. As a result, the company had to sign a new leniency agreement with the CGU. The hope is that problems like this will never happen again. About the Clean Company Act, I could talk for hours on this point, but I have few minutes to do. So I will only make one specific remark. I believe that the law should be amended to centralize the competence for prevention, fight of corruption in a single agency, a federal anti-corruption agency with formal autonomy. In relation to the OECD report phase 4, this new report was published a few weeks ago. Just to have an idea, the phase 3 report was published in October 2014. Just one information I would like to bring. The report says that 43 of the 56 new bribery big cases, I mean, equivalent to 76% of the cases are linked to companies implicated in the car wash investigation. That's very impressive. Going ahead to talk about the impacts of the Operation Car Wash on Brazilian business organizations. As mentioned previously, Operation Car Wash, despite all its defects, played a very important role, I do think. It virtually revolutionized the culture of companies regarding the non-acceptance of endemic corruption. I think that we needed a strong bulldozer, may I say, to open the way for compliance and to make the Clean Company Act a law with concrete effects. And then a question, two questions, do you need Operation Car Wash, a new one, super judges, super prosecutors? And these responses are obvious. Whenever a legal judicial system needs a major operation like this to fight against systemic corruption, it means that the system is not functioning properly and is not fulfilling its role. The same goes to figures like super judge or super prosecutor. Going ahead, just to finish, I am naturally optimistic, my friends. Comparison of the situation 10 years ago with that prevailing now regarding doing business in Brazil shows that the country has made significant progress, especially in the prevention of corruption by Brazilian companies. For this reason, despite the occasional presence of bad governments at all levels, the institutions are indeed making progress, and that's the importance. The institutions are making progress. I believe that in the corporate environment, Brazil companies will follow suit regarding improvement of their compliance system. And I'd like to finish mentioning a famous quote made by Toni Morrison, the American writer who won the Nobel Prize in 1993. She said, "If you find a book you really want to read, but it hasn't been written yet, then you must read it. Sorry, you must write it. A Country with No Corruption is the book we want to read. It hasn't been written yet, but trust me, Brazilian companies are trying to write this book. Thank you very much.
Thank you, Mauricio. That was an excellent presentation. Thanks to Renata, too, for a very, very nice presentation. Cesar, I'll turn it over to you.
Thank you, Chris, Renata, for having me. Thank you for this invitation. It's a pleasure to be sharing this panel with you and Mauricio, and to be, in a way, back to GW, although virtually. I will pick up on what Mauricio just said. Brazil became involved very, very effectively with the WTO GPA, and we all thought that was a very promising initiative, exactly in the direction that Mauricio mentioned of improving the system. It was very frustrating, as you will see in a few minutes, when Brazil decided to withdraw its accession offer, at least for the time being. But we are all optimistic that this is a temporary situation that will be resolved in the future. Just very quickly, the WTO GPA is a plurilateral agreement within the framework of the World Trade Organization. It has currently 49 member states, and Brazil became an observer of the GPA in 2017. Very quickly, it moved to apply for accession in 2020. Its accession offers came in a very fast succession, but unfortunately, in May 2023, as we will see, Brazil decided to withdraw those offers. Next, please, Chris. Brazil is not the obvious candidate for GPA accession. It has a very large domestic market. It's the largest domestic market in Latin America. Until 2023, in fact, Brazil was the only one that was actually negotiating its accession. Argentina, Colombia, Panama had been observers, or have been observers, since the 1990s, and have not moved to accede. So we will see some of the reasons why Brazil decided to do that before withdrawing. Next, please. In a separate move, and Renata has already mentioned that, in 2021, Brazil changed its Government Contracts Act. This change is unrelated to the GPA, but it's very consistent with the idea of adopting more international best practices, and which leads to the fact that the harmonization side of joining the GPA is relatively easy for Brazil right now, because most of its government contracts provisions are already consistent with the GPA principles. Next. Brazil's interest in joining the GPA, which was expressed in May 2020, came basically from the government. It was not a private sector driven initiative, but it was basically led by the government with the interest in reducing costs, increasing competitiveness, and being more in line with international practices, given Brazil's interest in joining OECD. So that was part of that was the context in which Brazil decided to accede. But there was, from the beginning, a very strong private sector resistance. Next. Right after Brazil decided to join, although the process was led by the government, it started a very interesting democratic process to determine the offers that Brazil was going to make. So that involved very wide public consultation with the private sector, but also with subnational government entities which are affected by the GPA. Next.
Just to comment, Cesar, on this.
Yeah.
When we've talked to states that are emerging from a let's say a communist past without and that want to join the GPA, this thing that you're talking about is a very important difference. The idea that there would be communications back and forth between the government and industry and government and civil society in addressing the GPA, it makes for a much stronger process, because the government has then full information from the private sector what the impacts might be, and that hasn't been the case in some of the post-Soviet states that have considered it.
Yeah, I think this is a very important lesson to be drawn from Brazil's process, even though it has. Chris, you can move to the full slide in this case. Even though Brazil's process has been stalled in a great deal due to private sector resistance, the fact is that there was a lot of dialogue in the construction of Brazil's offers, and so that process was relatively transparent. As we all know, the offers are confidential, but the process was relatively transparent. It was fast, and it involved a great deal of dialogue. The main private sector entity involved in this is what's called the National Industry Confederation. It's an association of Brazil's largest corporations, and as we will see, they voiced very strong concerns about joining the GPA. Next. Before we move on, let's talk a little about why Brazil decided to join, because that's relevant to understand why any country, especially an emerging economy, decides to join. Next. As I mentioned, the first reason, and that was what was in the government's mind, was to increase competitiveness and reduce costs, basically by bringing a larger pool of possible suppliers to the government. And it's important to understand, or to notice, that between 2011 and 18, only a little less than 7% of the federal government's purchases were awarded to foreign companies. And so even though Brazil has always had, allegedly or supposedly, a system that welcomes foreign suppliers, the hard fact is that foreign suppliers had always a difficult time being awarded contracts in Brazil. And together with increasing access to the Brazilian market to foreign companies, and therefore reducing costs for the government, the other direct benefits of the GPA is access to the public procurement market of the current 49 member states of the GPA within the negotiated GPA coverage. Next. But there are some indirect benefits that are also important. One of them is the possible improvement in the public sector governance. And it's interesting to notice that although the GPA is not an anti-corruption convention, its focus is not to fight corruption. Its ethical standards, general principles, transparency requirements are all in line with fighting corruption. And it's interesting to notice that when Brazil decided to join, if you looked at Brazilian newspapers, the news were that Brazil was joining the anti-corruption convention of the WTO. Next. Another important benefit is the gains in terms of how domestic law is interpreted. Brazil has always had a formalistic approach to public procurement, and accession to the GPA into an exposure to international practices may help overcome that. It's important to notice that Brazil has already taken measures to reduce hidden barriers and increased participation of the foreign bidders. The 2021 Government Procurement Act has rules specifically addressing international public bidding and foreign supplier participation. Next. And finally, another benefit is for Brazil to exert more of its regional leadership in Latin America. As I said, Brazil was the first one to decide to exceed. Now Costa Rica is doing it. Costa Rica had been an observer for a while, and so that's probably related somehow to the visibility that the GPA acquired in Latin America after Brazil decided to exceed. Next. And yeah, that's what I had just mentioned. And yeah, please, next. Yeah, so if we look at the other side, some costs and difficulties of GPA accession. Next. The first one, and that's the main concern of the private sector in Brazil, is what's nicknamed the Brazil cost, which is basically all the encumbrances that Brazilian companies have to face because of an inefficient tax system, bureaucratic requirements, and things that make it difficult for them to compete with foreign companies. Next. The National Industry Confederation research that was made to substantiate its participation in that public consultation process showed that, and I'm going to translate this for you, that in the company's view, the facilitation of the participation of foreign bidders would have high or would have what level of impact on their business. And 44% said that there would be a high impact. 28% said that there would be medium impact. So we see that the great majority of companies feared the impact of foreign companies in their business. Next. On the other hand, only 8% of the companies thought there would be a high impact in their easier access to foreign markets. So the flip side of the GPA coverage, the access to foreign markets, was actually seen by companies as very limited. Next. We do need to harmonize some standards, some legal standards. But as I said, they are generally consistent with the GPA, and so there are limited changes that would be required. Chris, I think we can fast forward the section of the harmonization because they are relatively covered. Yeah. Yeah. So let's stop here. Thank you. So before we got to this stage, just to give you a quick review of the potential difficulties in harmonization, there are, as I said, some formalistic approaches and some hidden barriers in foreign participation in biddings in Brazil, but they have mostly been addressed by the new 2021 Government Contracts Act, and so all those difficulties, they are relatively easy to solve. But now what we have is an initiative made by the new administration, the Lula administration in 2023, that altered the scenario regarding the GPA and decided to withdraw the offers made by Brazil. Brazil had made very aggressive offers. Next. Brazil submitted its first offer already in 2020. Next, Chris, please. No, in February 2021, Brazil submitted its first offer. It was already very aggressive. It was widely acknowledged by WTO as an extremely positive sign from Brazil, including a large number of state-owned entities and in a wide coverage in all aspects. Next. That was expanded in November 2021, and so the number of, especially the number of government entities covered, the subnational entities, increased in 11 more states. And next. And we got to the final offer, the third offer in June 2021, with 20 states plus Brasilia. In comparison, that's larger than the US's coverage. The US covers 37 states out of 50, if I'm not mistaken. So proportionately, Brazil's offer was larger in that regard. Next. However, as I mentioned, in coming to the end, Brazil in May 2023 decided to withdraw its offers. In an optimistic view, like Mauricio's, this is a withdrawal of the offers to exceed. And basically what, next slide, please, Chris. Basically what's in the government's mind, and I refer you to this article that my colleague Rafael Schwind and I wrote about this. It's on the course's materials. Basically, the main concern, among other concerns that Brazil had, but the main concern was that by making those very broad offers, Brazil was relinquishing its leverage in the negotiation of allegedly more important bilateral trade agreements, especially the one between Mercosur and the EU. And in this article, we make a comparison between the two coverages so that you can understand that better. But our hope is that as soon as we are able to finalize at least the most important bilateral agreements, we will, as a country, we will be able to refocus our efforts to join the GPA and be able to benefit from those trades that I mentioned before. So this was what I wanted to share with you at this stage. Thank you very much, Chris, again.
Thank you, Cesar. So we have a couple questions for you, Cesar, in the Q&A, if you want to take a look at that. And then I would like to ask the panel just overall to kind of close this out. I want to ask the panel what you all consider the legacy now. We've started with a car wash scandal as a starting point. What do you consider the legacy of the car wash scandal? And if we could start with Renata, what do you think is the legacy of the car wash scandal?
Personally, I think we could see through the presentations that we have been updated our legal framework and working really hard in our fight against corruption since the car wash operation. And also before, but the car wash operation was a big standard. Despite that, despite the clear improvement, personally, I think we still have a way to go regarding the political influence in our legal system.
Thank you very much. Marisa, do you have comments on what you think the legacy of the car wash scandal is?
Yes, I think that car wash has changed the mindset of our companies, the mindset of the controlling shareholders, the management, and this is very important. I know that, as I said before, some abuses happened, especially involving the federal courts in the city of Curitiba and Rio. But the legacy, and we expect that those abuses never happen again, but the legacy is linked with the change of culture that's very important in the context of anti-corruption efforts.
Good, thank you. I know, Cesar, you're working on the answers, but did you want to make a quick follow-up on what you think the legacy of the car wash scandal is?
Yeah, I think I agree completely, and I think what we have now after car wash is a very robust legal framework regarding anti-corruption. All that is here to stay. It's not going away because of any criticism that we may have regarding a car wash operation. We have now a strong framework for fighting corruption. We have awareness on the part of companies that there is a real risk of prosecution. We have developed, I think, institutionally, a lot of experience on the side of the government. Renata and Mauricio mentioned the number of leniency agreements that have been signed so far, which means the number of agreements that have been negotiated by the government. All that is a built-up experience that will serve well Brazil in the future.
Thank you very much. So we've got a question, Cesar, from Allison Anthony. She said, what was Brazil's offering with regards to local or racial preferences? What was the percentage to be excluded from the GPA? What can South Africa learn about Brazil's offers in terms of reservations that Brazil may have made prospectively in the GPA regarding local or racial preferences?
I don't think we had any racial preferences in the GPA offer, but one concern that that inspired the offer was the preservation of the government's ability to use public procurement for public policy issues, which means in general all these ideas of preferences for small companies, preferences for regional activities and things like that. But in general, the public procurement law in Brazil already addresses the possibility of establishing preferences. It's interesting to see, just as a side comment, that although the law provides for that, that's not used very much. It is used for the promotion of small and medium-sized companies, but not so much for local preferences. And but anyway, this is one of the issues that our article covers, and so I would recommend you to take a look at that. And Alain Jacquet also asked a question about what can be extended to South Africa from Brazil's experience. I think as I mentioned, the whole idea of a construction of an offer based on dialogue with the private sector and with subnational entities, that is very, very important. And in understanding how to address private sector concerns is also important. And as I mentioned, the private sector concerns were one of the main factors in Brazil's decision to withdraw its offers by now. And so being aware of those concerns and in trying to address them, I think will be a lesson that South Africa can learn from Brazil's experience.
Thank you very much. Any final words, Renato or Mauricio?
just like to thank you all. And I appreciate very much the invitation. And I expect to be here once again. Thank you.
Thank you, Mauricio. Renata?
Yes, thank you all so much. It was a pleasure to be here in the webinar with you. And thank you again, Chris, for your warm welcoming in GW Law as a visiting scholar. I really appreciate it. Thank you.
Thank you for joining us, Renata. And I just, as an American, I have to comment. So I was in Brasilia maybe 10 years ago with Cesar to talk about Brazil's possible joining the GPA. And I went and with Cesar and I addressed a packed meeting of folks who are very interested in this topic. Brazil is very good at planning on a very long trajectory. I was very, very impressed. I have to say, if I had a meeting in Washington of how we could plan things 10 years down the road in international trade, cooperation, and procurement, I'd be sitting by myself. So congratulations to a very effective effort in Brazil. Thank you all for joining us. And as I said, the materials will be available. The video from today's session will be available at publicprocurementinternational.com. And we will also be posting the recording on the YouTube page for the GW Law Procurement Law Program. Thank you all. Have a great day. Take care.
Thank you. Have a good day.
Thank you.